Well, the primary emphasis in my practice is family law, or what is commonly known as divorce. Divorce consists of 5 parts. First, there's the actual divorce itself. Second, child-related matters, which include the parenting plan with time sharing and child support. Third is equitable distribution, which is a division of the marital assets and liabilities. Fourth is spousal support, or what is commonly known as alimony. Fifth is attorney's fees and court costs. Florida is a no-fault state. Basically put, one spouse does not have to prove up and allege a factual basis such as cruelty, abandonment, or adultery in order to obtain a divorce in the state of Florida. Second, child-related matters. If the parties have a child or children, then consideration must be given to the establishment of a parenting plan with time-sharing arrangements as well as child support. Florida law no longer designates one parent as the primary residential parent or custodian, and the other parent as secondary residential parent with rights of visitation. Parenting plans involve a variety of matters which the parties will either agree to or the court will establish by way of an order. In either event, the general expectation is that the parties will communicate with each other regarding material matters that impact their minor children, such as schooling, health, religion, and extracurricular activities. This is what we call shared parental responsibility. In some instances, the court will award ultimate decision-making authority to one parent. This is called sole parental responsibility. The parenting plan will also delineate how the parties are to communicate with each other, how they are to communicate with their children, and what third persons may be involved, such as family, friends, and professionals such as doctors and daycare providers. Finally, the parenting plan will also specify a time-sharing arrangement. Basically, this sets out when the children are with one parent and when they're with the other parent. This can include days during the school year, summer, and specific holidays. Of course, the hope is that the parents will agree to a specific time-sharing arrangement that will take into consideration not only their work schedules, but also the age and specific needs of the children. Child support is an obligation of both parents. A parent's child support obligation is established in accordance with Florida's statutory guidelines. Under Florida law, both parties are required at a minimum to exchange financial affidavits and other financial information. This is called mandatory disclosure. This information is used in order to calculate both parents' child support obligations. In some instances, a parent may be unemployed. That parent is then expected to perform a diligent job search in order to become employed. If a parent is voluntarily unemployed or underemployed, then the court may impute income to that parent for purposes of calculating his or her child support obligation. The court also has the authority to enforce child support orders via its contempt powers. Florida is an equitable distribution state. First, we separate out the parties' non-marital assets and liabilities. Then we determine what are the marital assets and liabilities and valuate same. Once we've done that, we then equitably divide or equally divide the marital assets and liabilities. This is the starting point. In some instances, however, the court may award an unequal distribution of the marital assets or liabilities. Upon division of the marital assets and liabilities, one spouse may have a need for, and the other spouse may have an ability to contribute to, the support of the other spouse. This is known as alimony. 3 types of alimony exist in the state of Florida. First, there's permanent periodic alimony. Second, rehabilitative alimony. And third, bridge the gap alimony. Entitlement to attorney's fees and court costs is based on a review of all financial resources, including one's non-marital assets and liabilities.